Welcome to The Explainer. Today, we're diving into the absolute ultimate guardian of your capital, the Banking Regulation Act of 1949. Look, when you hand over your hard-earned deposits, just trusting the bank, that's not going to cut it. You need an ironclad legal shield. So let's explore exactly how this framework actually operates.
Think about it. Every single time you deposit a paycheck, you're placing immense trust in that institution. But what legally stops your bank from just taking that liquidity and, gambling it all on high-risk, speculative ventures? Well, let's get into it.
To really understand why we have this shield, we kind of have to look back at the wreckage that forced it into existence. Back in pre-independence India, the country was just plagued by a devastating wave of bank failures. Standard company law? Yeah, that just couldn't stop the bleeding. It became glaringly obvious that handling public deposits required a highly specialized and honestly pretty ruthless regulatory layer.
So here's our roadmap for The Explainer. We'll unpack this whole framework in 5 steps. 1. Why regulate banking? 2. Rules of bank management. 3. Operational and financial limits. 4. RBI, the ultimate guardian. And finally, 5. Landmark court battles. Let's jump right in.
Section 1. Why regulate banking?
Now, what's really brilliant about Section 5B here is how it completely strips away any ambiguity. It legally defines banking strictly as accepting public deposits for lending or investment, which are withdrawable by check, draft, or otherwise. Basically, if you are holding public money on demand, you are in the banking business. Period. No exceptions.
But, the definition of exactly who falls under this protective net, that's really evolved over time. Step 1. The original 1949 Act was built specifically for commercial banks. Then, moving to Step 2, by 1965, that net expanded to bring cooperative banks into the fold. And finally, Step 3, a major amendment in 2020 extended the RBI's full supervisory power over to multi-state cooperative banks. This was huge because it finally ensured absolute parity across the board to protect all depositors.
Moving on to Section 2, Rules of Bank Management.
So the crucial point here is this ultimate filter, 51%. Under Section 10A, at least 51% of a bank's board must possess specialized knowledge in fields like banking, finance, law, or even agriculture. What this means is you can't just stack a bank's board with your business buddies, right? You absolutely need vetted experts calling the shots. And those management controls actually go way deeper. Take Section 10B. It literally dictates that appointing a whole-time chairman or managing director requires prior approval from the RBI. Furthermore, Section 16 flat-out prohibits having common directors across different banks. This is a formidable shield. It's specifically designed to prevent conflicts of interest and stop large industrial houses from just using public funds to build their own corporate empires.
All right, Section 3, Operational and Financial Limits.
And this brilliantly illustrates the sharp firewall that exists between banking and general commerce. Section 6 outlines permissible business, things like lending in safe custody. On the flip side, Sections 8 and 9 explicitly prohibit stuff like trading goods or holding non-banking assets like real estate for more than 7 years. Simply put, your bank cannot legally act like some speculative hedge fund or suddenly decide to start bartering commodities.
Another really major boundary is Section 20. It strictly prohibits banks from granting loans to their own directors or to firms where those directors have an interest. This is absolutely crucial. It ensures that the management team can't just treat the bank's massive pool of public deposits like their own private commercial piggy bank.
Now, the financial limits are just as rigorous. Under Section 17, before a bank is even allowed to declare a single dime in dividends to its shareholders, it is legally mandated to transfer at least 20% of its net profit straight into a statutory reserve fund. It's a built-in safety net.
And right alongside that, we have Section 18. This imposes a strict 3% rule, requiring non-scheduled banks to maintain a cash reserve of at least 3% of their demand and time liabilities. Basically, it acts as an immediate liquidity buffer. So if we hit sudden economic turbulence, the bank actually has cash on hand.
Which brings us to Section 4, RBI, the ultimate guardian.
You see, the Reserve Bank of India, the RBI, holds this absolute legal arsenal. We're talking Sections 22 and 23, which grant the power to give or completely revoke licenses and control branch expansion. Section 35 gives them the right to just walk in and unilaterally inspect a bank's books. They can even remove management and supersede the board entirely under Sections 36AA and 36ACA. But the real heavy hitter here? That's Section 35A. This gives the RBI the power to issue direct, legally binding directions in the public interest. If they need to step in to protect depositors, they have the ultimate authority to do so.
Let's move to Section 5, Landmark Court Battles. Because, as you can imagine, laws this uncompromising, they inevitably face massive challenges from very powerful entities in the highest courts. The syllabus you're seeing here highlights the specific landmark judicial precedents that basically acted as the proven grounds for this act. This is where the true limits of banking regulation were hammered out and tested.
So let's actually track how this evolved. It's quite a story. First, in 1959, the Sajjan Bank case established a core principle. Banking is not an absolute right, it's a privilege, entirely subject to regulatory approval. Then, skip to 1962, the Velikunal case. This one is huge because it affirmed the RBI's supervisory primacy over even the judiciary in certain technical matters. Basically, the court said, look, when speed is needed to save depositors from ruin, the RBI's expert judgment holds. Fast forward to 1970, the famous R.C. Cooper case absolutely cemented that strict firewall between banking and commerce. And more recently, in 2019, the Durrani Sugars case actually set some boundaries, clarifying the limits of the RBI's directive powers regarding insolvency. It proved that, yeah, even the ultimate guardian still has to operate within strict parliamentary parameters.
So what does this all mean? Well, the court takeaway is pretty clear. The Banking Regulation Act of 1949 truly remains the Magna Carta of Indian banking law. It's this incredibly sophisticated balancing act between giving the RBI administrative discretion while strictly adhering to constitutional mandates. And the whole shebang is meticulously designed to force banks to operate as public trusts, protecting you, the common depositor, above absolutely everything else.
We've already seen how the 2020 amendments modernized the act to protect cooperative bank depositors. But here's the real question. As things like decentralized finance, digital currencies, and complex algorithmic trading evolve at absolute lightning speed, how will a legal shield originally forged back in 1949 handle the digital bank runs of tomorrow? Definitely something to consider the next time you casually open your banking app. Thanks so much for joining me for this explainer, and I'll catch you on the next one.